Okay, Mr. Brown, if you would go to the podium there, please. Go on the record in People versus Jason Brown. This is file number 256851. The record should reflect that Mr. Brown is present here in the courtroom today. If I could have counsel.
Record, Your Honor, I call on
Larry Brown on behalf of Jason Brown.
This is the date and time set for sentencing in this matter. Mr. Brown, did you have a chance to go through the pre-sentence report with your client?
I have.
Mr. Brown, did you have an adequate opportunity to go through that report with your attorney?
I have.
Okay. I guess the first thing that I want to address with regard to the report, just so that I'm clear, because as I was looking at the guidelines, it's scored on a B grid with guidelines of 99 to 200, which is 16 years at the top end, which is in excess of what the face sheet indicates is the statutory maximum. So that kind of raised my brow a little bit. And I looked at the felony information, which cites aggravated possession of CSAM under 750-145C4. The face sheet of the PSI references that same crime, but the amended information is C4B. The face sheet of the PSI references C4A. They have different maximum penalties. C4B is a 10-year, even though that's still stored on the grid. So I guess I want to make sure, number one, that the PSI is correct. It lists the appropriate maximum possible penalty. Because it's different than what the information says. The information indicates it's a maximum 10-year felony under that statute. So that has a bearing when the guidelines are well above the statutory maximum as to what the court can actually sentence to here. So
this was entered as a half-second, Judge, which makes it 15 years.
okay, so it's not the statutory maximum, but that the habitual second is what makes it the 15. Okay, but I still want to make sure that we have the statute cited correctly, because there is still the discrepancy between the amended information and the face sheet, which
It should be MCL 750-145C4B.
C4B.
I don't, and again,
Okay.
Why they have A in there, I can't take that. I don't know.
Okay.
But that appears to be a typo. It should be C4B. And I think the reason it had the A in there, Judge, is because they're putting in the PAC code. That's the PAC code for it. PAC code is 750-145C4-A1. But the actual charge for it is MCL 750-145 small c parentheses 4 parentheses small b parentheses.
Okay.
And I think that's probably the reason for the confusion. That's the best analysis I can do.
Okay. Mr.
That
Brown.
was my understanding as well, Your Honor. This was habitual second. That was a 15 years.
Okay. So it is correctly on the B grid based on that statute. Okay, great. So we've got that cleared up. That being said, Mr. Brown, are there any other additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Yes, Judge. These are the defendant's 7, 8, 9 felonies. He was on parole for criminal sexual conduct, 4th degree force or coercion involving 2 other minors. I know because the mother of those victims has contacted me personally several times. The guidelines in this case are 99 to 200 months up to 15 years. As bad as the photos of the CSAM images themselves are, in addition to that, as indicated in the PSI and police reports, there was a video of an adult male having sexual intercourse with a perhaps 4 or 5-year-old female. This defendant is a danger to society. While it's true this time he was not the one engaging in sexual acts directly himself with minors. However, he's by obtaining, possessing, purchasing, having, using, however you want to say it, the type of materials he had, such behavior does promote others doing so because they have to make material in the first place. And as the court's well aware, under the criminal sexual abuse of minors statute and for criminal sexual abuse of material, actually each image can be counted as a separate victim. That wasn't done in this particular case, which would have given OB9 an additional 10 points. It wouldn't have changed the guidelines anyway because it only go from 60 to 70 points. So it would still be a level 5. But as this offense was committed while the defendant was on parole for another CSC offense involving minors, obviously probation is not in reality. And in order to promote society, specifically protect children in our society, the defendant in the people's position should be sentenced at the high end of the guidelines. Thank you.
Thank you, Mr. Brown.
Your Honor, Mr. Brown understands very fully what he did was wrong. He was very cooperative during the interview. He was very forthright with pleading. He didn't try to make excuses or anything like that. He came straight forward and said, essentially, yeah, I did this. I believe he was weepy at the time. I've had some long conversations with him, and I believe he is remorseful for this. He has been in prison. There were some things that had happened to him in prison that I won't go into on the record. Suffice it to say, they were not pleasant experiences. He has been trying to seek help. He has been begging for health therapy. He understands that he has this compulsion. And I don't think it is unique to him. It is, we view alcoholism, drunk driving, things that are done because of alcohol, but we view that as a disease. Drug addiction, we call those addictions. They are diseases. Even though people commit crimes while they have them, they are addictions. We try to treat them. He has been trying to get help, and rather than viewing it as some sort of a mental disease that I personally just do not understand, it is just viewed as a deviant, evil person. And that's not condoning the crimes that were committed. They are heinous crimes. And I understand exactly what Mr. Rolla is saying. But there are some underlying issues that are going on with him that it is very difficult for him to control this compulsion. He was trying to get some therapy. He, I believe, was in therapy for a while, but he had some issues with insurance. And you don't pay, you don't get anything. So he did take advantage of some things while he was in the jail. Any program that they would offer, whether it would be a Bible study, whether it would be any kind of a jail service, CMH coming in, he would always take advantage. He took advantage of things in prison. I'm not exactly sure what kind of programs they have in prison, but I wouldn't suggest that they were probably the greatest in the world. So there's a lot to be done in that area. He fully understands he's going to prison. And he knows what he did was wrong. But again, this is something I can't explain. I can't explain an alcoholic's compulsion. Even when they know what it's going to do to them, a drug addict, when they know what it is going to do to them, they do it anyway. He knows that it's wrong. He knows that he shouldn't be doing this. And without proper therapy, he's never going to get this under control. And that's not to say that he didn't have a very difficult upbringing and things that have happened to him while he was growing up either, and that this shouldn't be punished, and he understands that. But I would ask the court to take all of those things into consideration and follow the recommendation. Thank you, Judge.
Thank you. Mr. Brown, was there anything you wanted to say?
Just want the court to know that I do know it was wrong. And that try anything to have in my life to never let this happen again. Sorry.
All right, Mr. Brown, I did read through the report, so I'm familiar with what happened in this particular case. There's also a lot of information in that report about your background and your circumstances and so forth. I do think that you've experienced some things, particularly in your childhood, some abuse that I'm sure contributed to what's going on now. Unfortunately, when somebody's abused as a child, it tends to become a cycle and they end up abusing people as an adult, and it's a cycle that continues. And much like domestic violence, it's really unfortunate that you were the victim of that as a child, because I think it makes it really hard for you to overcome that later as an adult, and it in many cases ends up with that person being an abuser themselves, which I think has happened here. And so I want you to know, I think as the court, I recognize that that's a contributing factor here. And I think that's a mitigating factor. Unfortunately, what you engaged in here is a very serious crime. It's carries with it very harsh penalties, because the end user of this type of material ends up causing the production of more material. The fact that there is an audience for this, there's the fact that people will click on this and watch it and seek it out, gives the people who are making it a motivation to make more, and that results in more and more victims. And Mr. Roll is right. Every single person in every one of those images is a victim who, as a child, may go on to victimize someone else later. And so your actions help perpetuate that cycle of abuse. And that's why we look at it as a very serious offense that carries with it serious consequences, because number one, there needs to be a punishment for you, but number two, there needs to be a deterrent effect so that other people who are thinking about trying to access this material understand that there's a serious penalty to be paid for it because of the collateral effects. In addition to that, you do have a lengthy criminal history. You do have 2 prior sexual assault related crimes, 1 prior violation of the Sex Offender Registration Act. You've been on probation 6 times, 7 jail sentences, and 2 prison sentences prior to this. Looking at all of these circumstances as a whole, past efforts at rehabilitation, the concerns that I have based on your history and your actions in this case, that those are impulses that are not under control and will lead you to victimize further individuals if you have the opportunity. Those things and the need to protect the community outweigh the mitigating factors here, and convince me, given your record, your history of these types of crimes, your participation in this offense, and the lack of prior rehabilitation, that a sentence at the high end of the guidelines is appropriate, again, for the protection of the community primarily, because I do have concerns that you would continue to engage in this activity, harm other individuals. So the court finds that a sentence of 120 months or 10 years to 15 years in the Michigan Department of Corrections is necessary, again, for the protection of the community, and the court's view that rehabilitation is unlikely. You do have credit for 76 days served. Court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $204 state cost. You do have the ability to seek an appeal of the sentence. Mr. Brown, if you can.
Your Honor, I don't think it's been printed out.
I'm printing it right now. I just didn't want to do it all.
Okay. Brown, we're going to provide for you some papers that explain to you what your appellate rights are, as well as how to request a court appointed lawyer to help you with them.
It should be plenty.
I'm going to take a short break while that's occurring. Jordan, the sheets here from the jail with that.
Big drive.
Be back on the record in just a few minutes.
All rise.
Time to break this one down. This sentencing hearing with Judge George Mertz was steady, thorough, and firmly by the book, but it still had a few moments worth noting. Right out of the gate, the judge zeroed in on a discrepancy in the paperwork, whether the statute listed in the pre-sentence report actually matched the amended information. That might sound like dry housekeeping, but in court it matters a lot, since the wrong subsection could change the maximum penalty. Judge Mertz calmly worked through the mix-up, identified it as a typo, and moved on. That's classic Mertz, no drama, just careful attention to detail. Once that was squared away, the hearing turned to the bigger picture, the defendant's long record and the sentencing recommendation. The prosecution, represented by Mr. Rolla, made a clear and forceful case for a high-end sentence. His argument was simple. Every image involved represents a victim, and the defendant was not just passively sitting on these materials, but actively perpetuating the cycle by seeking them out. He connected the dots between individual actions and broader societal harm. And while his delivery wasn't flashy, it was effective. You could sense that he believed strongly in the need to protect the community, and that he wanted to leave no room for leniency here. On the other side, defense attorney Larry Brown had a different task. He wasn't trying to excuse the conduct, but to humanize his client and push for the court to see him as someone with a compulsion that could, in theory, be treated. He used analogies to alcoholism and drug addiction, emphasizing that his client was remorseful, cooperative, and even seeking therapy where possible. It was a sincere presentation, but it also had the air of an uphill battle. The defense's argument wasn't about changing the outcome, but about softening the perception. Jason Brown himself spoke briefly, apologizing and saying he had tried everything to ensure it wouldn't happen again. His voice carried some genuine remorse, though it was clear the court had to weigh more than just the words in that moment. Judge Mertz's reasoning in delivering the sentence tied everything together. He acknowledged Jason Brown's difficult background, including abuse in childhood, and recognized those as mitigating factors. But he also emphasized that past efforts at rehabilitation had failed, that the defendant's history showed a troubling pattern, and that the risks to the community were too high. His ruling 10 to 15 years in the Michigan Department of Corrections wasn't just about punishment, but also about deterrence. The judge made it clear, when someone fuels demand for harmful material, more victims are created, and the law has to step in hard. The courtroom atmosphere throughout was measured. Nobody lost composure, and even with serious subject matter, the discussion remained professional. If anything, it showed the justice system functioning in a very workmanlike way, a judge ironing out technical issues, attorneys presenting their best angles, and a defendant given a chance to speak. The outcome may not have been surprising, but the process was thorough and respectful. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.